All right, welcome everyone, especially if you're a landlord here in the Kansas City area. You already know that managing property on both sides of the state line can be tricky. Today, we are diving deep into one of the biggest ones, the security deposit. It really seems simple on the surface, but trust me, getting this wrong can be a very expensive mistake.
So, let me just ask you straight up. Are you 100% confident that your security deposit process is completely bulletproof? Because even a tiny little oversight, something you might not even think about, could be exposing you to some serious legal and financial risk. Let's find out.
You know, this quote just hits the nail on the head. Security deposits are wrapped up in very specific state laws, and, well, saying you didn't know just doesn't fly in court. It's one of those areas where you can have the best intentions, but still end up in a world of trouble if you're not super careful. So here's our game plan. We're going to start by building that solid foundation at move-in, then we'll get into the nitty-gritty of the rules for Kansas versus Missouri. We'll also tackle that age-old debate, what's damage versus just normal wear and tear. We'll cover exactly how to return the deposit correctly, and finally, show you how a great system can act as a shield to protect you from all this stuff.
Okay, let's start right at the very beginning. The move-in. Now, this isn't just about handing over a set of keys. This is about setting up your first and, frankly, your most important line of defense to protect your property for the entire lease. The only way to do this right is to be absolutely meticulous. You have to create a complete record of the property's condition before the tenant even brings in their first box. And I'm talking detailed photos, videos, written notes for every room, every wall, every appliance. You're establishing the definitive baseline. And here's exactly why that's so crucial. That move-in report, that's your evidence. So when a tenant moves out a year, 2 years, or even 5 years later, you're not arguing based on memory. No, you're pointing to documented proof. That is the key to fairly assessing damages and, honestly, to shutting down any potential dispute before it even starts.
Now for the fun part. The part that trips up so many landlords here in KC. The rules are not the same on both sides of State Line Road. What's perfectly legal in Overland Park could land you in hot water over in Gladstone. You've got to know the difference.
Just look at this. You can see right away how different the basics are. In Missouri, you can collect up to 2 months' rent for a deposit. But hop over to Kansas, and it's capped at just 1 month for an unfurnished place. And get this, the pet deposit. In Kansas, that's an extra half month's rent you can collect. In Missouri, nope, it has to be included within that 2-month limit. Getting these details right is absolutely critical.
Now, both states give you this 30-day window to handle the deposit after a tenant leaves. But there's a subtle, and I mean really subtle, difference that can bite you. Kansas law says it's 30 days from the move-out date. Missouri law says it's 30 days after the lease termination date. Those two dates might not be the same, and you simply cannot miss this deadline.
And Missouri throws in a few extra hoops to jump through. For instance, you are required by law to offer the tenant the chance to be there for the move-out inspection. Also, you can't just put that deposit money into your personal checking account. It has to be held in a separate, federally insured trust account. It's these little details that make doing it yourself so risky.
Okay, let's fast forward to the end of the lease, the move-out inspection. This is where that super detailed baseline report we talked about really starts to pay for itself. This is the moment where you have to make that judgment call. Is this something the tenant has to pay for, or is it just a normal cost of doing business as a landlord?
So the law is actually very clear about this concept. You cannot charge a tenant's security deposit for what's called normal wear and tear. Think of it as the gentle, expected decline that happens when someone actually lives in a house. A little bit of fading, a few scuffs. That's on you, the landlord.
Let's make this real. Minor scuffs on the wall from a couch? That's wear and tear. A giant hole where a fist went through the drywall? Yeah, that's damage. Paint that's faded over 5 years is normal, but a bright orange accent wall that you never approved? That's damage. This is where most of the arguments happen, and having that move-in report with photos makes the whole conversation objective, not emotional.
And now, we've arrived at the final and honestly the most legally dangerous step of all, returning the deposit. This is not as simple as just writing a check and mailing it. There is a very specific procedure with documentation, and above all, you have to be on time to stay out of trouble. The only way to do this is to follow these steps to the letter. You do the final inspection. You prepare a written, itemized list of every single deduction. Then, you mail that statement along with whatever refund is left to the tenant's last known address. And it all has to happen before that 30-day clock runs out. There is zero wiggle room on this.
Look, when you handle this final step like a pro, with total precision, you basically eliminate the chances of a tenant taking you to small claims court. Plus, as a bonus, it gives you perfectly clean records, which makes your own bookkeeping and taxes so much easier. So after hearing about all these legal landmines and strict procedures, you're probably wondering, how can I possibly manage all of this perfectly every single time? Well, this is exactly where having an expert system in place becomes your compliance shield.
A really effective property management system takes this entire process off your plate. It makes sure every deposit is collected, stored in the right kind of trust account, and returned legally. The documentation is airtight, and all of this information, from move-in reports to the final accounting, should be available for you to see anytime you want. That's what real protection looks like. At the end of the day, a system like this is designed to do one thing: give you complete peace of mind. You can just relax, knowing that you're totally compliant, your investment is being protected, and you don't have to get bogged down in any of these complex and frankly stressful details.
So let me ask you one last time. Now that we've walked through all the state-specific laws, the crazy documentation requirements, and those unforgiving deadlines, really think about it. Are you still confident that your current process would actually hold up if a tenant challenged you? If you have even a tiny bit of doubt, please don't leave it to chance. You can protect your investment the right way. Give Alpine Property Management a call at 816-343-4520 or check out alpinekansascity.com to see how an expert process can take all the hassle and all the risk out of managing security deposits.